welcome to the Deep Dive. Today we're tackling a really fascinating and, let's face it, often debated part of the U.S. Constitution, the Second Amendment.
That's right.
You've shared just a fantastic collection of the key Supreme Court cases that have, really shaped how we understand this right. So our mission today is to pull out the crucial insights from these rulings, try to clear up some of the legal complexities, and, well, ultimately get a handle on what they actually mean for the right to keep and bear arms.
Exactly. And you've given us a great roadmap, really spanning more than a century of legal thinking on this amendment. We're going to trace how the court's view has, well, evolved. Pinpoint those pivotal moments and the core arguments in each of these big cases.
And we know you listening want to get this knowledge quickly, but, thoroughly too. So we're going to go chronologically. We'll pull out the key takeaways, those aha moments from each case, without getting totally bogged down in legal jargon.
Right. Keep it accessible.
Exactly. And helping us navigate this fascinating legal history and connect the dots is our expert speaker.
Yeah.
So, okay, let's dive right in. Way back. United States v. Cruikshank, 1876.
Cruikshank. Yeah, that's really the critical starting point. It pops up right after the Civil War, after the 14th Amendment was ratified.
Yeah.
And the case itself, it actually stemmed from something horrific, the Colfax Massacre in Louisiana.
Right.
Federal authorities tried to prosecute some of the people responsible using the Enforcement Act of 1870. The argument was that they'd conspired to violate the victims' constitutional rights, and that included their Second Amendment right to bear arms.
So this was basically an early test, wasn't it? Like, does the Bill of Rights, Second Amendment included, now apply to states or even private individuals after the 14th Amendment? What did the court say?
Well, the majority opinion written by Chief Justice Waite took a pretty narrow view. They held that the First and Second Amendments, they only restricted the federal government, not state governments, not private individuals. And there's a really key line about the Second Amendment where the court said the right to bear arms is not a right granted by the Constitution.
Interesting phrasing. So what do they mean by that?
Their thinking was that the amendment simply stopped Congress from infringing on a right that already existed. It didn't create the right itself, and it didn't stop states or individuals.
So if I'm getting this right, the feds couldn't interfere, but states could basically regulate arms however they wanted.
Precisely. The court said citizens had to look to their state governments to protect those kinds of rights from, other private citizens.
Right.
And since the violence in Cruikshank was by private citizens and the state officials weren't the ones being prosecuted, the federal charges just got thrown out.
Okay. Now, there was a dissent in Cruikshank, wasn't there? Did that justice see the Second Amendment differently?
Justice Clifford did dissent, yeah.
Yeah.
But it's important to understand his disagreement wasn't really about whether the Bill of Rights applied directly to the states then. His issue was more procedural. He thought the 14th Amendment's enforcement clause did give Congress some power to punish private interference with fundamental rights, but he felt the specific charges, the indictments, were just too vague.
I see.
So, yeah, even the dissent wasn't pushing for the Second Amendment to fully apply to states or private actions at that stage.
So what's the big takeaway for us from Cruikshank? Why is this 1876 case still, important to talk about?
Oh, it's hugely significant. Cruikshank basically kneecapped the federal government's ability to protect civil rights in the South after the war.
Right.
So for you, understanding this early limit on federal power is key. It essentially gave states a free hand to regulate arms, which, frankly, had devastating consequences for Black Americans. They were often disarmed by groups like the KKK, and under this ruling, they had no federal protection based on the Second Amendment.
Yeah.
And while McDonald v. Chicago in 2010 finally overturned the part about the Second Amendment not applying to states, for over 130 years, Cruikshank was this major barrier. It really shows how the early court saw the Second Amendment almost entirely as a federal limitation, with little relevance at the state level.
Okay, that sets the stage. So after Cruikshank, the court looked at the Second Amendment again pretty quickly, didn't they? Presser v. Illinois, 1886. What was going on there?
Yeah, Presser, also in that post-Civil War period. This one involved a guy named Herman Presser. He led this private militia group, basically armed guys parading in Chicago.
Okay.
Now, Illinois had a state law against forming private military groups or drilling with weapons without the state's okay. Presser got convicted under this law, and he argued, hey, this violates my Second Amendment rights.
And how did the court respond this time? Still sticking to the Cruikshank idea?
Yep, unanimously. The court basically reaffirmed Cruikshank. The Second Amendment only limits the federal government, not the states. Justice Woods, writing for the court, was super clear. The Second Amendment limits Congress and the national government, period.
So Illinois was free to regulate these private militias.
Exactly. Their law couldn't directly violate the Second Amendment as understood back then.
But wait, I remember reading something. Didn't they mention something about an individual right connected to militia service? That seemed like a slight wrinkle.
That's a really sharp observation. That's an important nuance. While they did say the Second Amendment didn't apply to the states, the court sort of acknowledged that citizens might have some kind of individual right to keep and bear arms, but specifically in the context of being available for militia duty. They hinted that if a state completely disarmed everyone, that might mess with the federal government's ability to raise a militia from the population.
Right, the federal militia pool.
Exactly. But the Illinois law wasn't a total disarmament. It just targeted these unauthorized private military outfits, so it was fine.
Okay, so Presser basically just hammered home that states had wide latitude on gun laws.
Pretty much. It cemented that the Second Amendment didn't stop state laws in this area, and it underlined that early connection people saw between the Second Amendment and the militia concept. For decades after Presser and Cruikshank, state gun control was basically entirely up to the states.
Until McDonald overturned that part too, right?
Correct. Just like Cruikshank, Presser's core holding about the Second Amendment not applying to states eventually got overturned by McDonald.
Okay, then we hit Miller v. Texas in 1894. This one seems a bit different, maybe less about the core meaning of the amendment.
You're right on that. Miller v. Texas wasn't really about breaking new ground on the Second Amendment's meaning. It involved a guy convicted of murder in Texas. He tried to argue that a state law violated his Second Amendment rights, and also, more broadly, that the Bill of Rights should apply to the states.
And the court's reaction?
Well, the Supreme Court, again, unanimously rejected Miller's claims, but mostly on procedural grounds.
The legal technicalities.
Exactly. They basically said Miller hadn't brought up his federal constitutional arguments, including the Second Amendment one, at the right time in the Texas state courts. Since he didn't follow the proper legal steps, the Supreme Court said, sorry, we're not going to fully consider it.
So this case was more about how to properly raise a legal challenge than about the Second Amendment itself.
Largely, yes. But even though they sidestepped the main Second Amendment question, the court did quickly mention the well-settled idea from Cruikshank and Presser that the Second Amendment only applied to the federal government.
Gotcha.
They also said they didn't find any 14th Amendment problems with his trial procedures.
So Miller v. Texas just kind of kept the status quo for the Second Amendment at that time.
Essentially, yeah. It solidified that non-application to the states in the 19th century. And it served as a reminder, about dotting your I's and crossing your T's legally if you want to bring a federal issue up from state court. It also kind of marked the start of a long, quiet spell for the Second Amendment at the Supreme Court. Nothing major for decades.
Right, until 1939, United States v. Miller. Now, this feels like a big one for the 20th century. What's the setup here?
Absolutely. After that long silence, Miller in 39 was the first major Second Amendment case in the 20th century. It came about because of the National Firearms Act of 1934, the NFA.
Okay, the federal law regulating things like machine guns and sawed-off shotguns.
Exactly. So two guys, Jack Miller and Frank Layton, got charged under the NFA for moving an unregistered sawed-off shotgun across state lines. They argued the NFA violated their Second Amendment rights.
Okay, so the court had to really grapple with the Second Amendment's meaning this time, didn't they?
They did. And the court, unanimously again, with Justice McReynolds writing, upheld the National Firearms Act. Their whole analysis really hinged on that phrase in the Second Amendment, a well-regulated militia.
Ah, the militia connection again.
Right. Justice McReynolds wrote that the amendment's purpose was to assure the continuation and render possible the effectiveness of these state militias.
So the ruling depended on whether the specific weapon, the sawed-off shotgun, had anything to do with a militia.
Precisely. The court famously said that since there was no evidence showing that owning or using a short-barreled shotgun has some reasonable relationship to the preservation or efficiency of a well-regulated militia, they couldn't say the Second Amendment protected the right to have one. Because nobody showed it was a typical militia weapon or useful for common defense, the court basically said its possession wasn't protected here. For years, Miller was basically read as saying the Second Amendment only protected guns reasonably related to militia service.
Wow. So this ruling really seemed to lock in that collective rights view, or at least a militia-centric view, for a long time.
It sure did. For almost 70 years, Miller was the main Supreme Court statement on the Second Amendment. Lower courts consistently used it to uphold gun control laws.
Right.
The reasoning was usually, well, unless this gun has a clear military use or the person is in an active militia, the Second Amendment probably doesn't apply.
But you mentioned it was a bit ambiguous.
Yeah, it's important to remember that. Miller didn't explicitly say there's no individual right to own guns, but its strong focus on the type of weapon and its link to the militia left a lot of room for interpretation, which mostly leaned toward regulation being okay.
Okay, which sets the stage perfectly for the huge shift. District of Columbia v. Heller in 2008. This was the earthquake, wasn't it?
Earthquake is a good word for it, absolutely. Heller was the first time since Miller, decades later, that the court really did a deep dive into the Second Amendment's meaning.
And it came from D.C.'s really strict gun laws.
Exactly. D.C. had essentially a total ban on owning handguns. And even for other guns you could legally own, like rifles or shotguns, you had to keep them unloaded and disassembled or bound by a trigger lock, basically inoperable at home.
Wow.
So Dick Heller, he was a special police officer in D.C. He wanted to keep a handgun at home for self-defense, but was denied a permit. He sued. The core question became, does the Second Amendment protect an individual right to have guns for private use, like self-defense, or is it only about militia service?
And the court finally gave a clear answer.
Very clear. In a 5-4 decision, Justice Scalia, writing for the majority, they struck down D.C.'s handgun ban.
Okay.
The court held, yes, the Second Amendment does guarantee an individual right to possess and carry weapons for self-defense. And crucially, this right isn't tied to militia service.
So self-defense became central.
Exactly. Scalia called self-defense the central component of the right, and he said handguns are the quintessential self-defense weapon for Americans.
Right.
So the big takeaway for you here is the court cementing this individual right.
Okay, but what about that militia clause? A well-regulated militia. How did they square that with this individual right?
Good question. The court called that the prefatory clause. They said it announces a purpose for the amendment securing a free state, but it doesn't limit the main part, the operative clause, the right of the people to keep and bear arms.
Oh.
They argued that the right of the people clearly means an individual right, just like it does elsewhere in the Bill of Rights. And they looked at a lot of historical evidence from the founding era to back this up.
But they also said this right wasn't unlimited, right? They didn't strike down all gun control.
Absolutely not. Scalia was very explicit about that. Like most rights, the Second Amendment right has limits. The opinion even listed examples of what they called presumptively lawful regulatory measures.
Like what?
Things like bans on felons or the mentally ill having guns, banning guns in sensitive places like schools or government buildings, and rules about how guns are sold commercially. And they also brought back that idea from Miller that the Second Amendment doesn't protect dangerous and unusual weapons that aren't in common use for lawful purposes.
Now, Heller was 5-4,
Oh.
so there were strong dissents. What was their counter-argument?
Oh, yeah. Justice Stevens wrote a major dissent. He basically argued the majority completely misread the amendment. He contended it was always meant to protect the state's ability to have militias, not create some broad private right for anyone to have a gun for any reason.
So back to the militia focus.
Right. He thought keep and bear arms historically meant military-related activities. He warned the majority was inventing a dramatic new constitutional right. And Justice Breyer wrote separately, too, focusing more on, like, the practical side. He favored an interest-balancing approach. He argued D.C.'s handgun ban was a reasonable way to deal with the city's serious handgun violence problem. So you really see two fundamentally different ways of looking at the amendment's history and how it applies today.
Okay, so Heller established this individual right, huge shift.
Yeah.
But it only applied directly to D.C., which is federal territory, right?
Yeah.
What about Chicago or New York or anywhere else?
Exactly. That was the immediate next question. And that brings us to McDonald v. City of Chicago just 2 years later, 2010.
Right.
After Heller, the big issue was, okay, does this individual Second Amendment right also restrict state and local governments? Chicago had a handgun ban very similar to D.C.'s.
So residents challenged it based on Heller.
Yep. They argued the Second Amendment, as interpreted in Heller, should stop Chicago, too. This whole case turned on that legal concept called incorporation.
A applying the Bill of Rights to the states through the 14th Amendment.
Exactly. The idea that certain really fundamental rights in the Bill of Rights limit state and local governments too, not just the feds. The question was, is the Second Amendment one of those fundamental rights?
And the court said yes.
Yes, another 5-4 decision. The court held the Second Amendment does apply to state and local governments through the 14th Amendment's Due Process Clause. Justice Alito wrote the main opinion. He concluded the right recognized in Heller is fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition.
So they looked back at history again.
They did. They talked about the post-Civil War era, concerns about southern states disarming the newly freed slaves, suggesting the right to bear arms was seen back then as fundamental and needing protection from state interference. So for you, McDonald is what made the Heller right apply nationwide.
So McDonald basically locked it in. The Second Amendment is a nationwide individual right, binding on cities, states, everyone. And this explicitly overrules those old cases, Cruikshank and Presser, on that specific point about applying to states.
That's exactly right. By incorporating the Second Amendment, the court made it clear state and local governments have the same constitutional limits as the feds when it comes to this right. And yes, it explicitly overruled the parts of Cruikshank and Presser that said the Second Amendment didn't apply to states.
And I assume Stevens and Breyer dissented again.
They did, yeah. Raising similar concerns about federalism, the power of states and cities to tackle their own local problems like gun violence.
Okay, so after Heller and McDonald set the big framework, we get Caetano v. Massachusetts in 2016. This one involves stun guns, right? Not firearms.
Correct. Caetano was about stun guns. Massachusetts had a law banning private possession of stun guns. A woman, Rahimi Caetano, had used one for self-defense against an abusive ex-boyfriend, and she got arrested for having it.
And she argued the Second Amendment protected her right to have it.
She did, but the top court in Massachusetts upheld her conviction. Their reasoning was kind of interesting. They said stun guns weren't arms protected by the Second Amendment because, well, they didn't exist in the 18th century and they were unusual and dangerous.
But the U.S. Supreme Court didn't buy that.
Not at all, unanimously, in fact, in what's called a per curiam opinion, meaning it's speaking for the court as a whole, not one specific justice. They threw out the Massachusetts court's ruling.
What was their reasoning?
They basically smacked down the Massachusetts court's logic, point by point, relying heavily on Heller. First, they said the Second Amendment isn't limited to weapons that existed back in the 1700s. It covers all bearable arms.
Okay.
Second, they said the test isn't whether a weapon is useful for the military, like the Massachusetts court seemed to think. The test, straight from Heller, is whether the weapon is in common use by law-abiding citizens for lawful purposes, like self-defense.
And stun guns met that test.
The Supreme Court strongly suggested they did. They noted that hundreds of thousands of stun guns were owned by private citizens. So the implication was pretty clear that qualified as arms in common use.
So Caetano basically reinforced that Heller wasn't just about traditional guns. It applies to modern self-defense tools, too.
Precisely. It showed the breadth of Heller. The Second Amendment covers modern tools commonly used for self-defense, not just firearms from the founding era. And it reminded lower courts to stick to the actual tests laid out in Heller.
All right, which brings us right up to the very recent and very significant New York State Rifle and Pistol Association v. Bruen in 2022. This was all about carrying guns outside the home, right? Public carry.
Yes, Bruen was huge, and specifically about the right to carry a handgun in public for self-defense. New York had what's called a May issue system for getting a license to carry concealed.
May issue, what does that mean exactly?
It means getting a license wasn't guaranteed even if you met basic requirements. You had to convince the licensing official, often law enforcement, that you had proper cause. Basically, a special need for self-protection greater than the general public's.
Ah, so it was discretionary. Hard for the average person to get one.
Very hard. In practice, in places like New York City, you had to show some specific threat or unique circumstance.
And the Supreme Court said that proper cause requirement was unconstitutional.
They did. In a 6-3 decision, with Justice Thomas writing the opinion, the court struck down New York's requirement. They explicitly stated that the Second Amendment protects an individual's right to carry a handgun for self-defense outside the home, not just inside.
Okay, that's big. But the even bigger thing maybe was the new test they announced, right? The text history tradition test.
Absolutely. That's arguably the most significant part of Bruen for the future. The court threw out the approach most lower courts had been using after Heller and McDonald. That approach often involved balancing the Second Amendment right against the government's public safety interests.
Right, like a two-step analysis.
Exactly. The Bruen court said no more balancing tests, no more means-end scrutiny. Instead, the new rule is this. If the Second Amendment's plain text covers an individual's conduct, like carrying a handgun for self-defense, the Constitution presumptively protects that conduct.
Okay.
Then, to justify regulating that conduct, the government has the burden. It must show that its regulation is consistent with this nation's historical tradition of firearm regulation.
Wow. So courts now have to be historians, basically. Look back centuries.
In a way, yes. They have to examine whether there were analogous regulations back in, say, 1791 when the Second Amendment was ratified, or maybe around 1868 when the 14th Amendment was ratified. If there's no relevant historical analog, the modern regulation is likely unconstitutional. Understanding this new test is absolutely key to understanding where Second Amendment law is right now.
So applying that to New York's law, they didn't find a historical tradition of requiring proper cause to carry a gun publicly.
Correct. Justice Thomas wrote that while history shows some regulations on how people could carry weapons, like maybe not carrying them in a terrifying manner, there wasn't a historical tradition of flat-out denying the right to carry to ordinary, law-abiding citizens unless they proved a special need.
Did they say all licensing is bad? What about background checks?
No, they were careful about that. They suggested that shall-issue licensing regimes are probably okay.
Shall issue
Meaning officials must issue a license if the applicant meets objective criteria, like passing a background check, maybe completing safety training. The discretion is removed. New York's was may issue, which involved that subjective proper cause.
Got it. And Justice Breyer dissented again here. What was his main issue with this new historical test?
He did, joined by Justices Sotomayor and Kagan. His dissent was quite passionate. He heavily emphasized gun violence statistics, the sheer number of people killed or injured by firearms.
Right.
He argued the court should consider the real-world consequences and allow legislatures flexibility to address this modern problem. He blasted the historical test as unworkable, saying it's incredibly difficult for judges to act like historians and find clear answers in often ambiguous historical records. He really favored letting legislatures balance the right with public safety needs.
So Bruen has obviously had a massive impact already, right? Especially on public carry laws.
Oh, enormous. It immediately invalidated those may issue laws in New York and several other states, forcing them toward shall issue. And it's triggered a wave of lawsuits challenging all sorts of other gun laws, bans on certain types of rifles, often called assault weapons, magazine capacity limits, you name it.
And courts are now scrambling to apply this historical test.
Exactly. Lower courts across the country are grappling with finding relevant historical analogs, or lack thereof, for all these modern regulations. It's a very active area of litigation right now.
Okay, which brings us to the absolute latest case in our survey. United States v. Rahimi, decided just this year, 2024. This one dealt with a federal law about domestic violence restraining orders.
That's right. Rahimi tested how that Bruen text, history, tradition framework would actually work in practice, specifically regarding a federal law that prohibits people subject to domestic violence restraining orders, DVROs, from possessing firearms.
And there was some doubt about whether that law would survive Bruen.
There was. The Fifth Circuit Court of Appeals, which covers Texas, Louisiana, and Mississippi, had actually struck the law down. They applied Bruen's historical test pretty rigidly and said they couldn't find a clear historical precedent from the founding era for disarming someone based on a civil protective order, especially without a criminal conviction.
But the Supreme Court disagreed with the Fifth Circuit.
They did. In an 8-1 decision, with Chief Justice Roberts writing for the majority, the Supreme Court reversed the Fifth Circuit and upheld the federal law.
Okay, so how did they square that with Bruen's historical test? Did they find a direct historical analog after all?
Not exactly a direct one-to-one match. What they did was clarify the Bruen test. The Chief Justice wrote that the historical inquiry isn't about finding a historical twin or a dead ringer. The law isn't trapped in amber.
Ah, so some flexibility.
Exactly. The court said the focus should be on whether the modern regulation is relevantly similar to historical ones, considering the principles underlying those older laws. They looked at history and found a tradition of laws aimed at disarming people perceived as dangerous to others.
Like what kind of historical laws?
They pointed to things like old surety laws, where someone who threatened violence could be forced to post a bond to guarantee good behavior, and if they didn't, they might face consequences, potentially including being disarmed. They also mention laws against going armed in a way that terrified the public or committing a breach of the peace with weapons.
So the idea was that the modern DVRO law fits within that tradition of disarming dangerous people.
Precisely. The court reasoned that since a DVRO requires a specific finding by a court that the person poses a credible threat of physical violence to an intimate partner or child, disarming that person is consistent with the historical principle of keeping weapons away from those who might misuse them dangerously.
And it was 8-1. Who dissented?
Justice Thomas was the sole dissenter. He had written Bruen, and he argued the majority wasn't applying his historical test faithfully. He felt they were watering it down by relying on analogies that weren't close enough. He maintained there wasn't a clear historical analog for disarming someone based on a civil order finding potential future dangerousness rather than a criminal conviction.
So Rahimi seems really important for understanding how Bruen will actually be applied. It suggests the historical test isn't maybe quite as rigid as some feared, especially when it comes to regulations targeting people deemed dangerous.
That's a very accurate takeaway. Rahimi clarifies that while history is central after Bruen, courts can use analogical reasoning. It suggests that laws aimed at preventing demonstrably dangerous individuals from having guns can still be constitutional under this framework, provided there's a relevant historical tradition addressing similar societal problems, even if the mechanism is modern. It shows the court trying to balance the Bruen framework with pressing public safety concerns like domestic violence.
Well, wow. We have certainly covered a ton of ground, just journeying through, nearly 150 years of legal history there.
Yeah.
Looking back at all these cases, Cruikshank in 1876 all the way to Rahimi right now in 2024, it's really quite something to see how the Supreme Court's understanding of the Second Amendment has shifted and evolved.
Absolutely. It's a genuine transformation. We went from an interpretation that really limited the Second Amendment to the federal government and mostly saw it through the lens of state militias,
Right.
to this firm recognition of an individual right to keep and bear arms primarily for self-defense, a right that now, thanks to Heller and McDonald, applies in the home, and thanks to Bruen, extends into public spaces as well.
And the way the court even evaluates gun laws has changed dramatically, ending up with this current focus on historical tradition from Bruen, maybe slightly refined by Rahimi.
Exactly. The methodology itself has evolved significantly.
Well, hopefully for everyone listening, this deep dive is giving you a clearer, more concise picture of this really complex and, often contentious area of law. It's just fascinating to see how these landmark rulings connect and continue to frame the debates we still have today about gun rights in the U.S.
Indeed. And, thinking about this whole evolution we've just walked through, especially with this relatively new emphasis on deep historical dives after Bruen, it really makes you wonder, what's next? What might be the next major Second Amendment challenge to reach the Supreme Court? Will it be about specific types of firearms, like so-called assault weapons or large-capacity magazines?
Or maybe nailing down what counts as a sensitive place where guns can be banned.
Or perhaps further clarifying who qualifies as too dangerous to own a gun, following up on Rahimi. It's clear the court's work interpreting the Second Amendment isn't finished. It really highlights how it remains a very living and actively debated part of the Constitution.